Hello and welcome to our today's lecture on Introduction to Law of Torts. In this lecture, we will discuss definition of tort, difference between tort and quasi-contract, and tort and crime. Definition of tort. The term tort was introduced into English law by French lawyers and judge courts of Normandy and Aberdeen kings of England. Tort means civil injury or wrong. In French, tort means wrong. The word tort is derived from the Latin word tortum, which means twisted or crooked or wrong, and is opposite of word rectum, which means straight. A person is said to have committed wrong if he does not behave in a straight way. Tort is difficult to define for variant reasons because law of torts is based on decided cases. Secondly, because this is still a growing law and no satisfactory definition can be given. Let's review some of the definitions of tort. Some of the important definitions which indicate the nature of this branch of law are: number 1, according to the Limitations Act 1963, and I quote, "Tort means a civil wrong which is not exclusively a breach of contract or breach of trust." Number 2, Salmon says that tort is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. Number 3, according to Winfield, tortious liability arises from the breach of a duty primarily fixed by the law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. Number 4, Fraser says, it is an infringement of a right in rem of a private individual giving a right of compensation at the suit of the injured party. The basic idea which is indicated by these definitions is, firstly, tort is a civil wrong, and secondly, every civil wrong is not a tort. There are other civil wrongs also, the important of which are a breach of contract and breach of trust. As stated, no such scientific definition of tort has been possible which could explain this wrong by mentioning various elements, the presence of which could be considered to be a tort. The various definitions which have been attempted try to follow a negative approach. They explain the nature of tort by either distinguishing it from other wrongs or by mentioning some of the elements which are found in a tort but are not there in other wrongs. When some wrongful act has been done, it has got to be seen first whether it is civil or a criminal wrong. If the wrong is found to be civil one, we have to see whether it exclusively belongs to any recognized category of civil wrongs like breach of contract and breach of trust. If we find that it is not exclusively of the other civil wrongs, then we can say that it is a tort. Is it law of tort or law of torts? In this connection, Salmon has posed the question. The question is it the law of tort? That is every wrongful act for which there is no justification or excuse to be treated as a tort, or is it the law of torts, consisting only of number of specific wrongs beyond which the liability under this branch of law cannot arise? Winfield preferred the first of these alternatives, and according to him, it is the law of tort. According to this theory, if I injure my neighbor, he can sue me in tort, whether the wrong happens to have particular name like assault, battery, deceit, slander, or whether it has no special title at all, and I shall be liable if I cannot prove lawful justification. Salmon, on the other hand, preferred the second alternative, and for him, there is no law of tort, but there are law of torts. The liability under this branch of law arises only when the wrong is covered by anyone or the other nominated torts. There is no general principle of liability, and if the plaintiff can place his wrong in any of the pigeonholes, each containing a label tort, he will succeed. This theory is also known as pigeonhole theory. According to Salmon, Just as the criminal law consists of a body of rules establishing specific offense, so the law of torts consists of a body of rules establishing specific injuries. Neither in the first case nor in the next there is any general principle of liability. Because of the difference in approach, Winfield's book on the subject is entitled Law of Tort, whereas Salmon's book is entitled Law of Torts. Each theory seems to have received some support. In 1702, Ashby versus White clearly established in favor of the first theory, recognizing the principle ubi jus ibi remedium, that is, every right needs remedy. Holt C.J. said that if man will multiply injuries, action must be multiplied too, for every man who is injured ought to have recompense. Similarly, in 1762, Pratt C.J. said, torts are infinitely various, not limited or confined. Pollock also supported this view. The theory is also supported by the creation of new torts by the courts of law. For instance, the tort of deceit in its present form had its origin in Pasley versus Freeman, 1789, inducement of breach of contract in Lumley versus Guy, 1853, negligence as a separate tort in the beginning of the century, the rule of strict liability in Rylance versus Fletcher, 1868, inducement to a wife to leave her husband in Winsmore versus Greenbank, 1745, and the tort of intimidation in Rooks versus Barnard, 1964. Tort is the area of law where, in response to private or civil wrong or injury, the courts provide the remedy of allowing a lawsuit for damages. Thus, the goal of tort law is to restore the victim to his or her former condition. The development of tort law in India is in scattered manner, but still provides for effective remedies. Most of Indian tort law was developed after British colonization. Tort law is said to be development of the old, every right needs remedy. The law of torts as administered in India in modern times is the English law as found suitable to Indian conditions and as modified by acts of Indian legislature. The law of torts or civil wrongs in India is thus almost wholly the English law, which is administered as rules of justice, equity, and good conscience. The term tort is derived from Latin word tortum, which means crooked. The police don't enforce a tort law. It is civil action taken by one citizen against another, and in court by a judge, and in rare cases, defamation by jury. Tort law is not codified in India. This means whenever an exigency arises, a precedent shall be set up to take care of peculiar situation. It has been noted in the Union Carbide case that Section 9 of CPC, which enables a civil court to try all suits of a civil nature, impliedly confer jurisdiction to apply the law of torts as principles of equity, justice, and good conscience. Historically, there was no general principle of tortious liability, but the king's courts gave remedies for various forms of trespass, for direct injuries, and later allowed an action on the case for harm indirectly caused. Other forms of harm later became redressable, for example, libel and slander, and distinct forms of action developed to redress particular kind of harm, so that the law of tort was concerned with number of recognized kinds of wrong, each with distinct requirements and procedure, statute added, new entitlements to claim, for example, in cases of fatal accidents, and new grounds of liability. Case law has extended liability, for example, from physical injuries to mental injuries, from intentional harms to harms done negligently, that is, by failure to show the standard of precautions deemed necessary in the circumstances. It remains the case, however, that the law of tort is a collection of circumstances in which the courts will give a remedy, normally by way of damages, for legally unjustified harm or injury done by one person to another, rather than a general principle of liability applicable to manifolded cases. It is potentially confusing to think of tort as connected with wrongs, as the wrongful element consists only in there having been a breach of legal duty, which may be purely technical and not involve any moral delinquency or criminality. In tort law, the principle of vicarious liability applies. In joint tort, all are liable for the whole harm caused with right or relief. If the plaintiff was himself wholly or partly to blame for the damages awarded may be reduced in proportion to the degree in which he was in fault. The standard of care and precaution which imports liability for harm is generally failure to take the care and precautions which were reasonable in the circumstance. But in certain cases, strict liability applies where the defendant is liable if he failed to avoid the evil consequences, unless he can establish one of certain limited defenses, and in cases of breach of statutory duty, the liability may be absolute. That is, there is liability if the prohibited harm happens at all, irrespective of precautions. Torts may be classified into those involving intention, those involving negligence, and the wrongs of strict liability. They may also be classified into torts affecting the person, for example, trespass, negligence, the family, wrongful death of relative, reputations, libel and slander, property, for example, trespass to land or goods, nuisance convergence, economic rights, deceit, inducement of breach of contract, injurious falsehood, and certain miscellaneous tort such as conspiracy. There are certain kinds of conduct such as infringement of privacy which are not yet but may come to be recognized as actionable tort. The normal remedy for a tort is an award of pecuniary damages in compensation for the harm done. In personal injury and the death cases, the computation of damages involves many complicated issues. In some circumstances, for example, nuisance injunction is a competent remedy. We may define tort as a civil wrong which is redressable by action for unliquidated damages and which is other than a mere breach of contract or breach of trust. Thus, it may be observed that number 1, tort is a civil wrong. Number 2, this civil wrong is other than a mere breach of contract or breach of trust. Number 3, this wrong is redressable by an action for unliquidated damages. Tort is a civil wrong. Let's understand it in depth. Tort belongs to the category of civil wrongs. The basic nature of civil wrong is different from a criminal wrong. In the case of a civil wrong, the injured party, that is, the plaintiff, institutes civil proceedings against the wrongdoer, that is, the defendant. In such a case, the main remedy is damages. The plaintiff is compensated by the defendant for the injury caused to him by the defendant. In the case of a criminal wrong, on the other hand, the criminal proceedings against the accused are brought by the state. Moreover, in the case of a criminal wrong, the individual who is the victim of the crime, that is, the sufferer, is not compensated. Justice is administered by punishing the wrongdoer in such a case. It is, however, possible that the same act done by a person may result in two wrongs, a crime as well as a tort at the same time. In such a case, both the civil and the criminal remedies would concurrently be available. There would be civil action requiring the defendant to pay compensation as well as a criminal action awarding punishment to the wrongdoer. Tort is other than a mere breach of contract or breach of trust. Let us understand this statement. Tort is that civil wrong which is not exclusively any other kind of civil wrong. If we find that the only wrong is a mere breach of contract or breach of trust, then obviously it would not be considered to be a tort. Thus, if a person agrees to purchase a radio set and thereafter does not fulfill his obligation, the wrong will be a mere breach of contract. It is only by the process of elimination that we may be able to know whether the wrong is a tort or not. First, we have to see whether the wrong is civil or criminal. If it is a civil wrong, it has to be further seen if it exclusively belongs to another recognized category of civil wrongs, like breach of contract or breach of trust. If it is found that it is neither a mere breach of contract nor any other civil wrong, then we can say that the wrong is a tort. It may be noted that there is a possibility that the same act may amount to two or more civil wrongs, one of which may be a tort. For example, if A delivers his horse to B for safe custody for a week, and B allows the horse to die of starvation, B's act amounts to two wrongs: breach of contract of bailment and commission of tort of negligence. Since both the wrongs are civil wrongs and damages is the main remedy for any kind of civil wrong, the plaintiff can claim damages either under the law of torts for negligence or for the breach of contract of bailment. He cannot claim damages twice. Tort is redressable by an action for unliquidated damages. Let's understand this statement. Damage is the most important remedy for a tort. After the wrong has been committed, generally it is the money compensation which may satisfy the injured party. After the commission of the wrong, it is generally not possible to undo the harm which has already been caused. If, for example, the reputation of a person has been injured, the original position cannot be restored. The only thing which can be done in such a case is to see what is the money equivalent to the harm by way of defamation, and the sum so arrived at is asked to be paid by the defendant to the plaintiff. There are other remedies also which could be available when the tort is committed. It is also just possible that sometimes the other remedies may be more effective than the remedy by way of damages. For example, when a continuing wrong like nuisance is being committed, the plaintiff may be more interested in the remedy by way of injunction to stop the continuance of nuisance rather than claiming compensation from time to time if the nuisance is allowed to be continued. The idea of mentioning the remedy by way of damages in the definition is just to explain the nature of the wrong. Apart from that, the fact that damages is the most important remedy for tort, and generally it is the only remedy after the tort is committed, indicates that the wrong is a civil wrong rather than a criminal wrong. Damages in the case of a tort are unliquidated. It is this fact which enables us to distinguish tort from other civil wrongs like breach of contract or breach of trust, where the damages may be liquidated. Liquidated damages mean such compensation which has been previously determined or agreed to by the parties. When the compensation has not been so determined, but the determination of the same is left to the discretion of the court, the damages are said to be unliquidated. It is possible in case of a contract that the contracting parties at the time of making of the contract may make a stipulation as regards the amount of compensation payable by either of the parties in the event of a breach of the contract. It is genuine pre-estimate of the compensation for the breach of the contract. It will be known as liquidated damages. There is no possibility of any such predetermination of damages by the parties in the case of a tort. Generally, the parties are not known to each other until the tort is committed, and moreover, it is difficult to visualize beforehand. The quantum of loss in the case of a tort, therefore the damages to be paid, are yet to be determined at their discretion of the court. Such damages, therefore, are unliquidated. The nature of a tort can be understood by distinguishing tort and crime, tort and duty in other civil cases, viz. A contract, a trust, and quasi-contract. Tort and crime distinguished. The wrongs which are comparatively less serious are considered to be private wrongs and have been labelled as civil wrongs, whereas more serious wrongs have been considered to be public wrongs and are known as crimes. According to Blackstone, wrongs are divisible into two sorts of species: private wrongs and public wrongs. The former are the infringement or privation of private or civil rights belonging to individuals, considered as individuals, and are thereupon frequently termed civil injuries. The latter are breach and violation of public rights and duties which affect the whole community, considered as a community and are distinguished by the harsher application of crimes and misdemeanors. There are various wrongs which find their place both under criminal law and law of torts. Some examples of such wrongs are assault, defamation, negligence, conspiracy, and nuisance. The definition of any one of these wrongs may be different under civil and criminal laws. For the purpose of civil liability for any one of the wrongs, the rules of law of torts will be applicable, and for the purpose of criminal liability, the rules of criminal law will apply. Generally, when the wrong is a serious one or affects a large number of members of the public, it is placed under criminal law. For instance, if a person causes an obstruction outside a residential building affecting only the residents of the building, it would be considered as a tort of private nuisance. If, however, a similar obstruction is caused in the middle of a public road, it would amount to offence of public nuisance stated in section 268 IPC. The rules applicable in cases of tort are generally different from those in the case of crime. For example, in the case of tortious liability for the wrong of defamation, truth is in itself a defense, whereas in an action for the offense of defamation, the defense of truth can be taken if the publication was made for public good. Since tort is considered to be a private wrong, the injured party himself has to file a suit as a plaintiff. If at any stage the injured party likes, he may agree to a compromise with the tort feasor and withdraw the suit filed by him. In the case of crime, on the other hand, even though the immediate victim is an individual, the criminal wrong is considered to be a public wrong, that is, a wrong against the public at large or wrong against the state. The criminal proceedings against the wrongdoer are, therefore, not brought by the injured party but by the state. Moreover, except in certain exceptional cases, the law does not permit a settlement in criminal cases between the wrongdoer and aggrieved party, and thus the compounding of an offence is, as a general rule, considered to be unlawful. In the case of tort, the ends of justice are met by awarding compensation to the injured party. In the case of crime, the wrongdoer is punished. The idea of awarding compensation to the injured party under civil law is to make good the loss suffered by him. The punishment under criminal law protects the society by preventing the offender from committing further offences and deterring him and other potential offenders from committing wrongs. Although payment of compensation to the injured party is a civil remedy to be provided by the civil courts in certain exceptional cases, as provided by Section 357 CRPC 1973, even a criminal court, while passing judgment, may order that the injured party may be paid compensation out of the fine imposed. Such amount of compensation may not be sufficient as compared to the loss suffered by the injured party, and if subsequently a civil suit is filed in respect of the same matter to claim compensation, the civil court shall take into account any sum paid or recovered as compensation under Section 357 CRPC 1973. Imprisonment is a form of punishment awarded under criminal law. Under civil law also, arrest and detention may be made. There is, however, a basic difference between the detention made in civil and criminal cases. Under criminal law, the imprisonment is made by a way of penalty for a wrongful act having been already done, whereas under civil law, the idea is to put pressure upon the defendant to perform certain duty, and the defendant is released when the duty has been performed. For example, in a civil case judgment, debtor may be arrested in execution of a decree under Section 57 CRPC. Such a person is released even before the expiration of fixed term if the decree is satisfied. Sometimes the same set of facts may constitute both a tort and a crime. The civil and criminal remedies in such a case are not alternative, but they are concurrent. The wrongdoer may be required to pay compensation under the law of torts. He may also be held liable under criminal law. For instance, if A digs a ditch on a public road resulting in an inconvenience, to the public at large, A has committed the offence of public nuisance as defined in section 268 IPC. If X, a passerby, falls into that ditch and thereby gets injured, A's act also becomes a tort of private nuisance as against X. Not only will A be punished under criminal law for the offence of public nuisance, he will be liable to compensate X under the law of torts. Tort and quasi-contract distinguished. When a person gains some advantage or benefit to which some other person was entitled to, or by such advantage another person suffers an undue loss, the law may compel the former to compensate the latter in respect of advantage so gained. The law of quasi-contract covers such obligations. It signifies liability, not exclusively referable to any other head of the law imposed upon a particular person to pay money to another person on the ground of unjust benefit. The law implies a contract on the part of the person so gaining the advantage to compensate the other party even though, in fact, there is no such contract. For example, A, a tradesman, leaves goods at B's house by mistake. B treats the goods as his own. He is bound to pay A for them. Similarly, if A and B jointly owe 100 rupees to C, A pays the amount to C. B, not knowing this fact, pays 100 rupees over again to C. C is bound to repay the amount to B. It is because of historical reasons that these obligations have been placed under separate categories. If English law had developed according to some scientific plan, quasi-contract would probably be coupled with many other cases in which the law compels the restitution of money or other benefit, but which for historical reasons we now classify under other rubrics of the law such as tort or trusts. The common point between a tort and a quasi-contract is that the duty in each case is imposed by the law. The main distinction between a quasi-contract and a tort is that the law of quasi-contract gives a right only with respect to money, and generally it is a liquidated sum of money. Law of torts, apart from a right to damages, grants other remedies also. Moreover, a claim from damages under the law of torts is always for an unliquidated sum of money. Another distinctive point is that in a quasi-contract, the duty is always towards a particular person, whereas under the law of torts, the duty is towards persons generally. With this, we come to the end of our today's lecture on definition of tort and difference between tort and quasi-contract and tort and crime. Hope it was helpful for you. Thank you for watching.